If your spouse calls a lawyer that you've already had a consultation with, can they retain that lawyer? That's the question of the day. My name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. So let's unwrap this or unpackage this question a little bit. So here's the scenario. You've already had a free consultation with a lawyer. You called somebody on the phone, they didn't charge you for it, and then your ex hires that person to represent them, and he actually pays them. It's not a free consultation. You actually engage them. The question is that permitted? Well, you have to understand one thing. Number one, the fact that you made a phone call in and of itself doesn't disqualify that lawyer necessarily from representing your ex. Here's the key, okay? The key is that if confidences were exchanged, then it doesn't matter whether you paid or not. It doesn't matter whether or not the consultation was paid or a free consultation. If you've shared confidences with the lawyer, that lawyer should not take on the other side because of confidential issues or confidentiality, and those rules are governed by the rules of ethics. But you got to understand one thing. Just because you called and you said, I want to get divorced and things aren't working out and, we got 3 kids and I'm sure, I want custody, he wants custody. Just because you've done that doesn't disqualify the other lawyer because none of that's going to be a confidence. Everybody's going to know that. In the filings, everybody's going to know you got married, you want a divorce, that there's custody and stuff like that. Technically, there's no reason in the world for a judge to disqualify someone just because another person called. However, here's what you're going to find. You're going to find that a lot of judges don't really want to get involved in the ethics of the issue. They're not interested. They're comfortable with the law and the statutes and the codes that govern the cases in front of them. If you file a motion to disqualify the other side, you're not asking for a decision that involves a code or a statute or a law that the judge routinely deals with. You're asking, is it ethical and is there a problem with it? Well, the court can have 2 reactions to that, both of which I've seen in practice. One reaction will be, and I've seen a lot of judges say that, he goes, look, as far as I'm concerned, these people have a contract. You don't have a contract. He can represent them. If you got a problem with that, if you think it's an ethical thing, file an ethics complaint. And then, you can file a grievance, whether or not they're going to think it's something. A lot of judges on the other end will say, well, it doesn't really look good. The optics aren't good in a situation like this. You talk to her and then you're representing him. I don't like the way it looks. I'm disqualified. That is, also, I think, an incomplete analysis, as was the first one. I think, in my opinion, what the judges should be doing is they should say, okay, there was a phone call. There's a lot of phone calls. A lot of people call free consultations. You can go disqualify 30 law firms because you decide to get a bunch of free consultations. The question is whether or not, as a result of that consultation, this person is now disqualified from representing your ex because of breaches of the rules of ethics, i.e., let's say, confidentiality. So in the situation that I set up, if that judge did the analysis number 3, he would say, wait a minute, I get that you made a call. I get that you said you wanted to get divorced, but there's nothing confidential about that. Everybody knows you're getting divorced. We're all in divorce court. There's nothing. You didn't say, if you said something like, I hid a bunch of money and I want this to be confidential, that's a different story. If you said, he doesn't know, but I really drink a lot, that's confidential. And that's, in that situation, that's bad because then the lawyers representing the other side has this information and that could hurt you. But the fact that you want to get divorced or something generic like that, if the judge is doing a careful analysis, the court will say not that, I don't want to get involved or go to the Board of Ethics. That's not how it works. The court should have a hearing, determine whether or not there were actual confidences shared. If there were, the guy's out and there's got to be another firm representing your ex. If there were no confidences shared, the court should probably leave it the way it is. I'll tell you something else too, something you got to think about. What do you think is going to happen when you disqualify this person? He's just going to get another lawyer. Well, at the end of the day, it's probably not going to make a difference. You want to make a little misery for him? You want to create a disruption in the case? It's going to delay your case also? You want to do that? Fine. I suppose you can. But, keep in mind that if you go before the judge, you don't know if he's going to grant your request or deny it. And if all you got is, I called for a free consultation and I didn't really share much, but I did call, so disqualify him, that's probably not going to play out that well. So these are all the considerations that you should think of in that as you have that analysis. If you have any questions about your particular case, give us a call. We'll be glad to help you out.
248-588-3330. 648